Hello, my name is David Schneider. I'm an estate planning attorney in Ventura County, California, and welcome to the first of a series of informational videos that I want to provide to you to help in understanding the estate planning process. When we talk about an estate planning process, we are actually trying to answer a number of questions up front as to what will happen in the event that obviously should we pass, or if we become incapacitated. What happens if we have children? What happens if our children are immature? What if, God forbid, a child passes away before us? What happens to my property? When will my children or my heirs inherit? An effective estate plan is going to answer all of those questions up front. The world of estate planning tends to be rather black and white. And with that, we can answer all of the questions that I just posed right up front, taking into account you and your opinions and your desires about what you want to have happen, not leaving those things to chance. The primary focus or the primary tool that we use when we're conducting our estate plan is the revocable living trust. First and foremost, revocable. The word revocable means amendable, changeable. The plan that we create today may or may not be the same plan that we want to use in 2025. People come in and out of our lives. Our thoughts change, opinions change, laws change. So we need something that we can bend to fit what our present set of circumstances are. That's what we mean by revocable or amendable. We also use the term living trust because, again, it is amendable. It's designed to be bent to fit what we need. It's also one of the few estate planning tools that operates while we are alive. Most people are familiar with a will. Wills work when we pass away. Living trusts work today, now, and at the time that you pass away. When we're talking about a living trust, we are talking about taking title to assets, the property that you presently own and will subsequently acquire, and retitling those assets into the name of the trust. So when we talk about that, we're literally talking about taking, as an example, your home, one of everybody's most primary and significant assets. We retitle the home into the name of the living trust. Well, once we do that, it's actually the trust that owns the home. So, what's most people's concerns? What do you mean I don't own my home anymore? Well, since the trust owns the home, we have to understand how the trust operates. There are three active persons involved in the operation of the trust, and the first one is called the settlor. The settlor is the person that creates the trust, the person that writes the trust. What I often refer to is the W's. That person is going to set the who, what, where, when, how, why, and all the particulars of what they want their living trust to say. Who is the settlor of the trust? You. You're the settlor of your living trust. Now, typically you are going to employ the working of an attorney, somebody like myself, to create that plan for you, to take all the legalese and put it together with your thoughts and your ideas. But ultimately, you write the estate plan. You write the living trust. The second person that's involved in our plan is called the trustee. The trustee is the manager of the trust estate. The trustee is going to make decisions about investments and mortgages and decide when to add property to the trust estate or take property away from the trust estate. They'll be responsible for taxes, insurance, accounting, deciding when to put a new roof on the house. The trustee of the living trust is you, or obviously for a married couple, the husband and the wife. They are the trustee of the trust. They're going to make decisions. What kind of decisions? Same decisions as you made yesterday are the same decisions that you're going to make tomorrow. The trustee manages the trust assets. Now, the trustee has a duty called a fiduciary duty, or a duty to act in the best interests of the beneficiaries. It's a duty of loyalty. So now we ask, who are the beneficiaries of the trust? The beneficiaries are the people that get the benefit of the trust. The majority of people that I speak with and that I interview, they want to immediately leap out and say, well, of course, my children are the beneficiaries of the trust. But this is not entirely correct. You remain the beneficiary of your trust so long as you are alive. The trust assets are held for the benefit of the beneficiary, which are you. You created the trust, you are managing the trust estate, and you're doing this work for the benefit of you. So even though we take title to the assets, as an example, your home, we take title out of your name and grant that to the trust, we have not restricted you in your use or enjoyment of the trust assets, because you set up the rules, you're handling the management, and you're giving those assets to the beneficiary, which is you. So our living trust is really designed to help you not just when you pass away, but during life right now, today. Now, there are two other people that are involved in our living trust estate plan. And that next person is called the successor trustee. The successor trustee is the person or persons that you nominate to become an active trustee when you can no longer be the trustee. So if the trust names a husband and wife as the active co-trustees, and one of them should become incapacitated or pass away, the surviving spouse is the trustee. If they are both unable or unwilling to act as the trustee, we now look to the successor trustee. This is a person that you name in advance who you have faith and confidence in. Come heck or high water, these people are going to be there, that they have your back. This is called a successor trustee. And we're looking to have who you name and who you have confidence in, rather than relying upon a court or somebody else to make that determination. Our fifth person that's involved is called the remainderman. And we call these persons the remaindermen because they will get the remainder. This is typically going to be your children, although it could be charity, extended family, good friends, anybody who you feel is deserving of having the remainder of your estate. So those are our five people. Settlor, the person that creates it; the trustee, the person that manages it; the beneficiary, the person that benefits from it. That's you, and you. Then we bring in a successor trustee when you can no longer act, followed by our fifth person, our successor beneficiaries, or our remaindermen. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call, David R. Schneider, 805-374-8777, or please visit our website at drs-law.com.